Hi friends, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today. There are some things expected of all lawyers. Some of them are very important, some of them are just professional courtesies, some are ethical responsibilities, and some are not. But at the bottom line, the things that are expected when you walk into a courtroom are, one, you're walking in there on time. And by on time, I mean 15 to 30 minutes early. In other words, if the court says we're going to start at 9, you need to be there at 8:30. And the reason you need to be there at 8:30 is because if you and your opposing counsel have an issue that needs to be taken up before trial, you can knock politely on the judge's door, ask to come in, bring in the court reporter, and you can cuss and discuss the issue in front of the judge in chambers, off camera, by the way, so that you can get this issue resolved before the jury gets here, and you don't have to push the jury out into the jury room and make them wait for 30 minutes. You know, they're all looking at their watch. And you do that as a courtesy to the judge and to the jury. Everybody knows this. Everybody who's tried cases knows this. And it doesn't matter whether you're doing a one-day trial or a 200-day trial, you do the same thing all the time. You get there early every day. The other thing you do is you start well before trial looking for issues that will need to be resolved. It's one of the reasons that lawyers file motions in limine. Motions in limine basically ask the court to take up before trial these evidentiary issues. Is this statement hearsay? Is this statement not hearsay? Is it admissible on some other basis? And then the judge has an opportunity to familiarize himself with that issue, and he'll make a ruling. And let's say the ruling goes adverse to you. He says, no, I don't think there's any reason for you to admit the defendant's prior criminal record. Just as an example. I'm not saying that would come up because usually it doesn't. And then you want to get that in, and something happens in the course of the trial that opens the door to that. For example, somebody says, well, I've known him all my life and he's never been a criminal. Well, at that point, you then have an opportunity to get in front of the judge and say, you know, we're here early today, and the reason we're here early today is you ruled on my motion in limine, and now I think they've opened the door, and I want to get this evidence in. So the judge has an opportunity to take that up. The other thing that you want to do before trial is you want to make sure you have all of your exhibits, all of your witnesses, all of the information possible that you can bring into that courtroom to get the result that you want. And you want to make sure that you've laid out for the other side all of that information. Well, last week there was an issue in the Young Thug trial, and I will let all of you determine what you think about the prosecutor's behavior here. The defense has raised an issue about untimely service of evidence that the prosecutor now wants to get in the form of a PowerPoint. And the judge, you may recall, I did a video several weeks ago about the judge being frustrated with the pace of the trial and frustrated about every day having to argue something new or re-argue something old. And he told them to work together, work cooperatively, otherwise we're going to be working nights and weekends here. And so he had made that, and he'd said, look, one of the things I'm going to do is if you try to get stuff in and it hasn't been cleared with the other side as it should have been, I'm going to suppress it. Watch this clip, and then we'll talk about what you think about the prosecutor's behavior and the judge's behavior in this particular segment. Let's watch.
I know that you were here early, and I know why you were here early. Okay. So, but focus. The focus is on why didn't we file this stuff months ago, and let's wind it out and air it out at that point in time. Okay. So I'm going to ask the state their issue on this. Are you cutting this out? Did you have discussions with Mr. Sharp, madam?
We did have discussions.
When?
Well, this morning.
That's too late. The evidence is excluded. The evidence is excluded. I'm going to exclude. I'm going to exclude because I told you that this was going to happen. No, 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 no. We're excluding that, and I'm going to exclude the PowerPoint that you all submitted. Well, you're not going to wholesale introduce it.
We had no intention.
All right.
Let's be real clear. We did not intend to introduce that PowerPoint today. I have personally reached out via telephone and called at least 2 members of the defense team and asked them to call me back. And I would like
But you all should not be identifying this stuff the moment of trial while the jury's sitting in a box. This is the last. I am not going to tolerate this any further. If you don't get together with your colleagues and flag issues and resolve them promptly, and if I have to take them up, remember, I can exclude them. We'll work the weekends, or we'll do a combination of both. So this time, I'm going to exclude those 2 sections.
Your Honor, Mr. Atkins, he confronted this witness with those sections. I last week let them know that we were introducing that.
If the exhibit's not ready and you haven't made, no, well, Mr. Shart's got objections to it.
Judge, Mr. Sharp can get in and have our evidence excluded every day that he makes an objection
No.
at midnight, and then comes in and says.
Well, then you all should have gotten your stuff together before then. Some of our juries, please. Some of our juries. Have a seat, madam. Have a seat. You better exclude that, and next time, make sure you're prepared.
Judge,
Make sure you're prepared next time. I'm not going to do this anymore. I'm just not. We are starting right now. It's 1:20. So
talk to them. He has said we don't agree.
then file a motion and get it before me, and we'll take it up. Both of you all have equally responsibility to do that.
The information they are seeking.
Oh, it's going to be inadmissible right now.
I'm saying, Judge, that you said to file a motion. There's nothing.
I'm not going to have any more discussion about this, madam. I'm not.
Talk to them this morning
I don't.
about that.
Well, you know what?
And I attempted to try to talk to them earlier this week.
Well, then that's why we have to.
Your Honor, so the court punishes the state because the defense.
I'm not punishing anybody, but but prior preparation prevents poor performance.
Be prepared, Judge. That's why I sent them what I sent them last week, a whole week and a half ago, 2 weeks. Your
I'm
Honor.
not. Well,
And I have said I would like to discuss.
our jury's coming in, madam. Our jury's coming in. Have a seat.
So a couple of things here. First of all, I've tried cases in front of numerous judges. Probably the last case that I tried was in front of Judge Callahan. And you knew when you tried a case in front of Judge Callahan that he was going to make a ruling, and that ruling was the ruling. Now, you could get by with once or twice saying, well, Judge, did you consider this? And maybe re-argue a little bit, and sometimes, very rarely, would he change his mind, but it was possible. But what you didn't do was throw a fit in front of the judge, because he would have given you one warning. All right, that's enough. Sit down. And if you kept rambling on and berating him about why you were right and he was wrong, he would say, all right, I think you need to pull out your checkbook and write a check to $100 to the court, and he would find you right there on the spot. It had the effect of anybody who tried a case in front of Judge Callahan knew they could not get out of line with the judge, and that if they did, they were going to get fined. And if the fine didn't stop them, then certainly spending the night in the county jail would more likely than not take care of that for you. I never had a problem with Judge Callahan in that regard, because I recognized from the tone of his voice when things were not going my way. And so I just made a record for appeal and went on. And then I didn't have to appeal because I won anyway. What's interesting about these things, in my opinion, is that when you are up there arguing, you're playing the short game. You want to win on this point. And sometimes the judge is doing you a favor when he's ruling the way that he's ruling, because if he ruled the other way and it came in and you wound up winning the trial, you were going to be going back on appeal later on, because he should not have admitted that evidence. There's some yin and yang with regard to how far you're going to go when you argue. This prosecutor, although clearly a zealous advocate, went too far, and she really looked unprofessional in that argument. If you notice the strident tone in her voice there at the end, where basically he said, "Our jury's coming in, go sit down," that to me suggested, as he turned away from her, that he was done and that we're not going to have this discussion again, period. That kind of thing is not something you want to have happen if you are a lawyer trying a case. Now, the ethical standards for lawyers are different than the ethical standards for prosecutors. The ethical standards for prosecutors are: the prosecutor is an administrator of justice, a zealous advocate, and an officer of the court. The prosecutor's office should exercise sound discretion and independent judgment in the performance of the prosecutorial function. The primary duty of the prosecutor is to seek justice within the bounds of the law, not merely to convict. The prosecutor serves the public interest and should act with integrity and balanced judgment to increase public safety, both by pursuing appropriate criminal charges of appropriate severity and by exercising discretion to not pursue criminal charges in appropriate circumstances. The prosecutor should seek to protect the innocent and convict the guilty, consider the interests of victims and witnesses, and respect the constitutional and legal rights of all persons, including suspects and defendants. That's what the prosecutor is supposed to do, and basically by playing outside the rules, which is what the court found that she was doing by not making timely disclosures and ignoring his previous warning, she got pretty much what he told her she was going to get if she did that. I think the judge gave the prosecutor here a lot of rope and allowed her to say a lot more than he probably should have allowed her to say. And he allowed her to get way too emotional. That is terribly unprofessional of her. The judge should have probably rebuked her much sooner, and he should have made it clear that his ruling was his ruling and to sit down and shut up. I think he probably did that, but he was reluctant to put some teeth behind it, and that's really the only failure that I see on the part of the judge here. Perhaps you guys have a different opinion. Now, in terms of ethics, I don't think she's fracturing any of the ethical boundaries here. The only thing that she's doing is not maintaining decorum in the court. And that is not usually something that you get into some kind of disciplinary trouble over. Usually that's just something that the court will remind you, hey, you're out of line, sit down, shut up, that sort of thing. I don't see very much room for the state to argue on appeal that this was a bad decision. Anyway, I thought you would enjoy that little vignette from the trial, and if you have any questions, put them in the comments down below. Like, share, subscribe, all that stuff we ask you to do. If you have the opportunity today, do something nice for someone. Go out of your way, open a door, maybe buy somebody lunch. Anything that you can do to make somebody's life a little bit better is a great thing. Thank you so much for watching. When you finish doing something nice for somebody, come on back here tomorrow and catch me down at the beach, and we can talk about something else that might be a little more fun than prosecutorial ethics. I try very hard not to be like all those other YouTubers who open up every video by asking you to subscribe before you've even seen the content. But now that you've gone a few minutes into the content, if you find this interesting and helpful, please subscribe. I'd consider it a personal favor. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.